I'm Attorney Zach Townsend with Pro Legal Care, here today to talk to you a little bit about amending your divorce decree. There are generally two ways to amend your divorce decree. The first way is based on evolving needs of the family and changes in circumstances that occur after the divorce decree is entered. These are usually referred to as a modification. You're eligible for a modification if you're dealing with a child-related issue and a substantial change in circumstances has occurred subsequent to the entry of the last order or the judgment for divorce. Typically, this refers to changes in the child's schooling, family structure, life events, the schedules of the parties, the employment circumstances of the parties, the age of the children, or the needs of the children. Those are the types of factors that are considered in determining whether a modification should be granted to change the parenting time schedule or to change the parenting plan. You also have a similar standard based on a quote, substantial change in circumstances when the child support is sought to be increased or decreased. Those are examples of ongoing possible changes or amendments to the divorce decree. The second type of amendment to the divorce decree is not ongoing but set for a limit of time only. Usually it's 30 days after the entry of the divorce decree. For example, you can file a motion to reconsider within 30 days after the divorce decree being entered. If the judge misapplied the law, or if one of the parties committed some kind of a fraud, then within 30 days you can file a request that the judge reconsider the judge's determination. That goes back before the same judge, which means that it's usually going to be the same decision. Similarly, you can file a motion to clarify. That'll help with ambiguities in the judge's order. You may also file a motion to vacate, which would be filed within 30 days of the entry of the judgment. Often a motion to vacate is when there is a divorce judgment that's entered in the absence of one of the parties. If one party fails to appear, the other party may get the relief that they're seeking by default. It's like when two baseball teams have a game and one of the teams doesn't show up, the other team wins by default. So if a default judgment was entered in your divorce case, there may be a motion to vacate filed within 30 days after the entry of the judgment. Those are usually granted. Separately from the trial court remedies that I just described, you also have the option to file an appeal with the appellate court. The appellate court oversees the trial court and makes a determination as to whether or not the trial court followed the law in making the decision that the trial court made. Like a motion to reconsider, the appeal must be filed within 30 days of the entry of the judgment. Unlike a motion to reconsider, the appeal does not go back before the same judge. It goes back before a different judge. These are examples of amending the divorce decree and other forms of post-judgment relief.